Moving on to question 7. Which case provides authority for the legal principle that a term is a condition when it's so important that without it, the parties would have not entered into the contract? And then I've got a series of authorities here. So I'm actually looking to match the law or the case to the legal principle. So it's not about agreement, intent, or consideration. It's about determining whether a term is a condition or not. Okay, so I actually know this off the top of my head that it's Associated Newspapers and Banks that is the case for that. How could you work that out if you didn't know it? Okay, well, there's a couple of ways. You could eliminate cases that you know it's not. So if you know some of these cases are about other things, for instance, Donahue and Stevenson comes from negligence, so it's out. Or you might know that the Commercial Bank of Australia and Amadio is actually an unconscionability case. You could rule them out, so that's one way to go forward. The other way to go forward is to try and isolate what area of the course the principle is from, and then go there and see if you have in your handy dandy hint sheet the specific case and see if it matches. Because I know that this is about terms, right? Saying which case provides authority for the legal principle that a term is a condition. I want to go to that part of the course. So you'll remember the first lecture, what we really deal with is simple apparent contracts. We deal with agreement, intent, and consideration. Then in the second part, in the second lecture of contract, we deal with enforceability, which has things like unconscionability and undue influence in it, which again is this case here. And then it deals with terms, right? And breach of terms and what the remedies are. So I know actually by knowing that rough structure of the course, I know that it's not going to be in my week 8 checklist, right? I know that it's actually going to be in my week 9 checklist. So if I go to my week 9 checklist and I can start to try and get an understanding of where it might be. This is a summary page of the whole thing, and I know that it's about this topic, right? The difference between a condition and a warranty. Okay, so that's the specific area that we're dealing with. So it's roughly at the end of our particular notes on terms. And what we can see is that once you have a term, you need to determine if it's a condition or a warranty. A term of fundamental importance is Associated Newspapers and Banks. And so once again, that's very clearly the case here for question 7. So a lot of that approach is actually trying to narrow in on the answer or eliminate ones that you know aren't the answer. Let's try question 8. David, an elderly man who does not speak English, entered into a written contract with Petra. David thought he was agreeing to lease a room in his house to Petra, when in fact he's agreeing to sell his house to her. Under which of the following principles would David most likely be able to avoid the contract? So again, it's kind of a most likely, not saying David is definitely going to get out of the contract, but under which of these principles? Now, it just so happens I've been in the specific area already around this in my handy dandy hint sheet about a lack of consent. And you can see here that we're talking about mistake, duress, undue influence, and unconscionability. And we see mistake, duress, mistake, and this favourable contract. You know, I've never heard of that before, so I've got no idea what that could possibly be. So it looks to me like it's an enforcement problem, just looking at these topics here. Now, I actually do remember what duress is. It's one of the simpler ones to remember, and it's that someone's being forced. There's a threat of harm, physical or to property or economic. And there's no real threat of harm here. Okay, there's no real threat to David. He's just either kind of mistaken or tricked, like he thought he was doing something when he was doing something else. So when I think about it, it's probably a case of mistake. It's going to be one of these mistakes. And you can almost work this one out from the terminology, right? Unilateral mistake is where one person makes a mistake. So in this case, David's made a mistake. Has Petra made a mistake? It doesn't really look like it. And if Petra hasn't made a mistake, I'm not sure it could be common or mutual mistake, right? Because it's only one person making a mistake. I'm going to say, well, look, it looks like if anything's going to apply, it's unilateral mistake. So I can go back and now check that on my sheet as to what unilateral mistake is, right? Generally, it doesn't allow, but it can be avoided where there's a fundamental aspect of the contract. And in particular, the fundamental aspect that we're interested in is non est factum. The general rule is that when you have a signed contract, it can't be avoided, but you can avoid it where a mistaken party had a good reason for not reading and they were mistaken about a fundamental nature of the contract. So here, does David have a good reason not to read? Well, he doesn't speak, and so therefore I presume he doesn't read English. Was he mistaken about a fundamental aspect of the contract? Well, he thought he was leasing a room, but he was selling her his house. That's fundamentally different. I still think David's going to have a hard time showing this in the real world, but out of all of these, unilateral mistake is the one most likely to allow him to get out of this contract. Unilateral mistake, non est factum. So that would be my answer for question 8. Question 9. Monica agrees to sell a block of land on the Brisbane River to Rodney for $500,000. When the time comes to perform the contract, Monica refuses to sell the land to Rodney as she's changed her mind. Which of the following statements is most correct? Now, look at this question. Monica has agreed to sell it for $500,000 when the time comes to perform the contract. So there is a contract, right? It's very clearly there's a contract. Monica is refusing to sell the land. So what's happening? Monica is breaching the term of the contract. She's promised us to transfer the land to Rodney. He's promised to pay $500,000. She's then refusing to do her part of the bargain. So this is really about a breach of condition, right? A breach of a term of the contract. So what happens when she breaches? A, Rodney cannot do anything as Monica's allowed to change her mind. Well, that's not true. That's the whole point of a contract, is that it's legally enforceable. So it says here, we have a contract, right? So if we have a contract, then this cannot be true. Rodney can seek an injunction from the court. Okay, well, what's an injunction do? An injunction is something that stops someone doing something. So what do you want to stop Monica doing? You don't want to stop Monica doing anything. So no, that doesn't make any sense. Rodney can seek an order of specific performance from the court. What's specific performance? Again, just to remind us, we can go to our handy-dandy hint sheet and we notice that here in remedies, we have damages and their purpose and then equitable remedies. So what are equitable remedies? Equitable remedies are specific performance and injunction. Specific performance is where we where the courts order someone to fulfill their part of the bargain. It's quite rare as an outcome, but something like a particular block of land here is a case where the courts might order specific performance, right? Because it's only this block of land. It might have a great view. It's got access to the river. So there's no alternative. Giving money might not substitute for actually having this block of land. So I think C is the answer. Rodney can order us, try to seek an order of specific performance. That would make Monica transfer the land to him. Let's just check D to be sure. Rodney has to agree to a higher price to convince Monica to sell the land. No, that's not true. He's got a contract. He can enforce it for the $500,000. So again, quite clearly to me, the answer here is C.